talks about declarant's last will and testament. Rule 8033, don't need special language for testator's existing state of mind in will cases. We have clauses that allows backward-looking statements when dealing with execution, revocation, identification, or terms of declarant's will. An example is a testator admitting what a declarant said on the subject makes sense because he is likely to be well informed on the subject, he is likely to be dead when the matter is litigated, and his own views of the subject may be trustworthy as live testimony by interested parties disputing the disposition of the state, and that's the policy. So, state of mind is not allowed when it's backward-looking, except with the last will and testaments. Statements to physicians, Rule 8034, statements for purposes of medical diagnosis or treatment, statements made for purposes of medical diagnosis or treatment describing medical history or past present symptoms, pain or sensations, the inception or general character, the cause of external source thereof, insofar as reasonably pertinent to diagnosis or treatment. Statement can be made to hospital attendants, ambulance drivers, or even members of family, not necessarily a physician. Compare with 8033, can be made to anyone, and contemporaneous has to be what we feel right now, then existing physical condition. 8034 can be made to a physician or someone who can get you medical treatment, and it can be conditions that have been there for a while. Past recollection recorded. 8035, recorded recollection, a memorandum or record concerning a matter about which a witness once had knowledge but now has insufficient recollection to enable the witness to testify fully and accurately, shown to have been made or adopted by the witness when the matter was fresh in the witness's memory, and to reflect that knowledge correctly. If admitted, the memorandum or record may be read into evidence, but may not itself be received as an exhibit unless offered by an adverse party. Must demonstrate 4 elements. 1. The witness' last present recollection of the matter. 2. The statement accurately reflects knowledge he once had. And 3. He made adopted statement, and he did so while the matter was fresh in his mind. Those are the 4 elements. Business records, 8036, records of regularly conducted activity and memorandum, report, record, or data compilation in any form of acts, events, conditions, opinions, or diagnosis made at or near the time or form of information transmitted by a person with knowledge, if kept in the course of regularly conducted business activity, and if it was the regular practice of that business activity to make the memorandum, report, record, or data compilation as shown by the testimony of custodian or other qualified witness, or by certification that complies with Rule 902.11, Rule 902.12, or a statute permitting certification unless the source of information, method, or circumstances of preparation indicate lack of trustworthiness. Here are the elements of the business records. Regular business, regularly kept records. 2. Personal knowledge of source. 3. Contemporaneity, recorded. 4. Foundation testimony, such as through the custodian of the records or other qualified witness who has first-hand knowledge of the record. Rule 805, hearsay within hearsay. Hearsay included within hearsay is not excluded under hearsay rule if each part of the combined statement conforms with an exception to the hearsay rule, provided these rules. If you have hearsay within hearsay, it will be admissible as long as each chain fits one of the hearsay exceptions. 801D2, authorized admissions of a party opponent allowed to speak for the company can be used. Public records, 8038. Public records and reports. Records and reports, statements, or data or compilations in any form of public offices, agency, setting forth clause A, mundane documents describing activities of the office. Agency reflects what agents or agency did, but not what they saw, heard, or concluded. Example is National Transportation Board record to show that they investigated a plane crash, but not what the agent concluded, saw, or heard. No restrictions against in a criminal trial. Clause B covers matters observed for legal duty by public officials subject to certain restrictions taken up below. Requires it be based on information acquired firsthand by government employee or agent of something that the agency or agent had official duty to report. Example, National Transportation Board report allows what he saw or observed but not his conclusion, but still exclude matters observed by police officers and law enforcement personnel in criminal cases. Clause C, factual findings relating to an investigation, directs that reports setting out agents' conclusions and factual findings are admissible, allows factual findings over hearsay objections. Example, National Transportation Board report sets out conclusion as to fault or blame is inadmissible. However, it cannot be offered against the accused in a criminal case. This exception is reliable because of the notion of government's interest in accurate record keeping plus persons' duty to act. To determine whether the sources of information or other circumstances are untrustworthy, has to be shown opponent that it is untrustworthy, timeliness of investigation, the special skill or experience of the official, whether a formal hearing was held on the level it was conducted, and rule doesn't require, though it is suggested by the advisory comment notes, and possible motivational problems. Alright, exceptions to the declarant being unavailable. Rule 804, hearsay exceptions, declarant unavailable. Hearsay exceptions that may be invoked if there's unavailability of testimony. You have to prove declarant is unavailable, and conjunctively, only if statement fits one of the 5 exceptions. 804A, definitions of unavailability. Claim of privilege, refusal to testify, lack of memory, death, illness, or infirmity, unavoidable absence. The former testimony exception, Rule 804B1. Former testimony is testimony given in deposition and testimony given by a witness at another hearing of the same or different proceeding. If the party against whom the testimony is now offered or civil action of the proceeding predecessor interest had an opportunity and similar motive to develop the testimony by direct, cross, or redirect examination. 2 elements for former testimony. Only need the opportunity to cross-examine. There has been similar motive to cross-examine in the previous hearing, which is a 104A question. Dying declaration, statement under the belief of impending death in prosecution of the homicide or a civil action proceeding, statement made by declarant while believing that the declarant's death was imminent concerning the cause of circumstances of what the declarant believed to be impending death, talking about naming the killer, the circumstances of the crime, majority rule, personal knowledge of the cause of the or circumstance of what the declarant believed impending death is required. Modern rule is common law rule now allows dying declaration in civil cases, but allows this only in homicide criminal cases. The common law is maintained. The common law rule was it applied only to homicide cases, thus not allowed in civil or non-homicide criminal cases. The way you show that a declarant was speaking under a belief in impending death, settled hopeless expectation of death. Belief in impending death. Majority rule, personal knowledge of the cause or circumstances of what the declarant believed to be the impending death is required. Hearing a man dragging his foot is enough. Example, suicidal notes. Courts disagree as to whether a dying declaration, no clear rule, don't have to die from what you think you're dying from for it to be a dying declaration. Declarations against interest, not the same thing as party admission. Rule 804b3, statement against interest, a statement that was at the time of its making so far contrary to the statement's declarant's pecuniary or proprietary interest, or so far tended to the subject of the declarant civil criminal liability, or to render invalid a claim by a declarant's interest against another, that reasonable person in the declarant's position would have made the statement unless believing it to be true. But in criminal cases, a statement tending to expose the truth, expose the declarant to criminal liability admissible in following circumstances only. If offered to exculpate the vindicate of crime of an accused, it is supported by corroborating circumstances that clearly indicate its trustworthiness, or if offered to inculpate charge with crime and accused, it is supported by particularized guarantees of trustworthiness. Statement against interest require unavailability and not limited to the parties. A party can introduce statement against himself, his own statement against interest. Statement of interest has to be against your interest when made. But statement of party opponent do not have to be against interest when made. Alright, 104A, another 104A decision is the forfeiture exception. And there are three elements. The statement made by a party that wrongly caused the declarant's unavailability. 2, intended the declarant to be unavailable. And 3, actually made the declarant unavailable. That's the forfeiture exception. Federal rule allows statements against penal interest and pecuniary and proprietary interest when penal interest offered to exculpate, exonerate, must have corroborating circumstances that clearly indicate the trustworthiness of the statement. Factors to look at to prove the trustworthiness of a statement. Speaker seeking to curry favor, spontaneity of the statement, relationship of the accused, credibility of the speaker. Was the speaker Mirandized? Suggests no pressure to speak. Also, corroboration, other details, personal family history, forfeiture exception. And then here we go to the catch-all exception, Rule 807. Texas doesn't adopt this catch-all because it leads to uncertainty of admissibility of evidence. Rule 807, residual catch-all, federal rules of evidence, admissible when not covered by other exceptions, have circumstantial guarantees of trustworthiness. The statement is offered as evidence of material fact. The statement is more probative on the point for which it was offered than any other evidence the proponent can procure through reasonable efforts. And the general purposes of these rules, the interest of justice, will be served by admission of the statement into evidence more probative than any other evidence available to prove. 6, proponent has to notify the other side sufficiently in advance before trial preparation to rebut. The court must determine the general purposes of these rules in interest of justice. Alrighty.